The 8 accused in this matter were convicted of murder. They acted with a common purpose. Consequently, Act 108 of 1997 provides for a minimum sentence of life imprisonment. However, the said Act further provides that in the event the court finding that substantial and compelling reasons exist justifying a lesser sentence, the court shall impose a lesser sentence. In the latter regard, the court has discretionary powers. In order to determine whether substantial and compelling circumstances justifying a lesser sentence exist, it is incumbent on the court to consider the nature and extent of the crime, the respective personal circumstances of the accused, the interests of the community, and all the circumstances of the particular case. It is, however, right that the court should guard against deviating from imposing a prescribed minimum sentence for flimsy reasons. Murder is the most serious offence a human being can commit. In this case, a young man lost his life within a few hours after his arrest. Although the murder was not pre-planned or premeditated, the facts prove that the form of mens rea was dolus eventualis. It means that the accused foresaw the possibility that the accused could die as a result of their conduct, but nevertheless did not refrain, stop or prevent the infliction of serious injuries on him, and therefore reconciled himself with his eventual death. The deceased was a family man who had obligations towards his dependents. His family is now left without a breadwinner. The emotional effect on the family is probably incalculable. This issue was dealt with in all the pre-sentence reports handed in as exhibits AA to HH. It is that the impact of the deceased's death on his family has to be taken into account. See the State versus Macia, 2011-1, SACR 40 SCA, paragraph 16. The personal circumstances of the accused are contained in the said pre-sentence reports. I deem it expedient to attach the said reports to this judgment. It includes the personal circumstances of the respective accused, their families, as well as a reference to the impact that the death of the deceased had on his family. The personal circumstances of the accused can be summarized as follows. They were members of the South African Police Force. All of them have good service records. None of them has any previous convictions. They have good family relations and dependents to care for. It was pointed out to me this morning that accused 8's health condition is not good. I was not informed about what his problem was. Apparently he was in hospital some time ago. The community depends on members of the police force for protection and safety. Rogue policemen, for obvious reasons, are unacceptable in society and cannot be tolerated. Although policemen are in many occasions subject to rude, provocative and aggressive behavior of members of the public, they are expected to conduct themselves in a proper and reasonable manner within the ambit of our laws. This includes that they have to respect the individual's rights entrenched in our Constitution. Of course, policemen are entitled to use reasonable force to effect lawful arrest. In this case, regrettably, that right was abused with dire consequences. It is so that, insofar as the initial arrest of the deceased is concerned, that only accused 1 and 2 were aware of the true facts. Both of them knew very well that the deceased's arrest was unlawful. Their wrongful conduct started with the decision to arrest the deceased. To that extent, the situation of accused 3 to 8 differs. On the probabilities, accused 3 to 8 were misled by accused 1 and 2 with words or conduct in accepting that the deceased was lawfully arrested. The wrongful conduct of accused 3 to 8 therefore commenced when the deceased against standard rules and regulations, was attached to the police vehicle and then dragged off behind it. Thereafter, unfortunately for all the accused, the unlawful conduct continued up to the point where the deceased was fatally injured in the holding cell. In the matter of the State versus Molgas 2001 SACR 469 SCA, paragraph 25, the court remarked as follows, and I quote, "If the sentencing court, on consideration of circumstances of the particular case, is satisfied that they render the prescribed sentence unjust, in that it would be disproportionate to the crime, the criminal, and the needs of society, so that an injustice would be done by imposing that sentence, it is entitled to impose a lesser sentence," close quotation. The whole incident that fateful day lasted a few hours and got totally out of control. However, taking into account the circumstances of the case, I've arrived at the conclusion that life imprisonment would be disproportionate to the crime. This was conceded by the State, and it was argued by defense counsel. In my view, there are substantial and compelling circumstances justifying a deviation from that sentence. These circumstances are the following. 1. The problem started when the deceased became arrogant and aggressive when confronted with a traffic violation by accused numbers 1 and 2. It justifies the finding that the deceased's conduct in respect of accused 1 and 2 was clearly provocative. In respect of accused 3 to 8, it has to be found that on the probabilities they subjectively believed that the deceased was arrogant and resisting lawful arrest. 2, the gathering of the angry crowd complicated matters. 3, the accused were policemen on duty. They have good service records and no previous convictions. They have now lost their employment. Their future is bleak. 4, in view of the unblemished records of employment of the accused, their rehabilitation seems to be a realistic proposition. 5, prior to being granted bail, they were kept in prison for a period of approximately 7 months. It follows that the court is now obliged to impose a lesser sentence than life imprisonment. To impose the most appropriate sentence is an onerous and difficult task. All relevant circumstances must be considered and balanced in accordance with the guidelines that have emanated from previous decisions of especially the Supreme Court of Appeal. The main purposes of punishment are prevention, retribution, deterrence, and rehabilitation. See State versus Rabi, 1975, 4 SA 855 AD at 861 to 862. The element of mercy, however, should also be kept in mind. In S versus Harrison, 1973, 3 SA 684 AD at 686A, the court remarked as follows, and I quote, "Justice must be done, but mercy, not a sledgehammer, is its concomitant," close quotation. In State versus Zonile, 1959, 3 SA 319 AD at 330E, the court emphasized that the punishment must fit the criminal and the crime. Due to the fact that the individual personal circumstances of the accused differ, each accused circumstances will have to be considered in order to determine whether it may result in the individualization of the sentence. I could, however, not find that the personal circumstances of any of the accused, despite the difference in their ages, differed to that extent from the others that it justified the imposition of different sentences. Although the personal circumstances of the accused are taken into account, it has been stated in the case of the State versus Villagasi, 2009, 1 SACR 552 SCA at paragraph 58, that in matters of a serious nature, those circumstances necessarily recede into the background. And that is exactly the position in this case. The aggravating features in this case speak for themselves. The arrest of the deceased and the dragging behind the vehicle was totally unnecessary, uncalled for, and not justified at all. The accused attempted to hide behind their right as law enforcement officers to use reasonable force to arrest and detain the deceased. They clearly abused this right. However, what made their conduct more reprehensible was their cowardly attack in the cell on a defenseless and already seriously injured man. What happened in the cell not only confirmed that they acted with a common purpose, but is regarded as a seriously aggravating feature. The continuous conduct of the accused concerning the injuries inflicted on the deceased was barbaric and totally unacceptable. It goes without saying that the community is entitled to protection against behavior of rogue police officers. Unfortunately, this protection can only to a limited extent be provided by the court in imposing severe sentences in an attempt to prevent and deter other potential perpetrators. The accused, unfortunately for them, did not show any remorse. In the pre-sentence reports, all of them maintained that they were innocent. However, a court should be slow and careful to, without more, regard the lack of remorse as aggravating. The accused were entitled to plead not guilty and are entitled to maintain this attitude, even today. True remorse, however, or contrition, on the other hand, is an important factor that could have had a mitigating effect on the sentence. See State v. Segers, 1972, SA 506 AD at 511G. Although accused 1 and 2 started the whole incident after having been provoked by the deceased, the difference in blameworthiness between them and accused 3 to 8 evened out when accused 3 to 8 participated in the assault on the deceased in the cell. Accordingly, there is no basis concerning their respective contributions requiring imposition of different sentences to which I have already alluded to. Therefore, in my view, the interests of justice in this case demand that there should be uniformity in the sentences of the accused, and accordingly that they should receive the same punishment. Finally, it is kept in mind that the appropriate sentence should be proportionate and commensurate to the crime in question. But as alluded to before, murder is and remains a most serious crime. It is unfortunate that the dependents of the accused will suffer as a result of the accused being sentenced to direct imprisonment. Direct imprisonment, however, is indeed the most appropriate sentence. After having considered all the mitigating and aggravating circumstances, the accused are sentenced as follows. You must now rise, please. Each of you are sentenced to 15 years imprisonment. Court adjourns.
Agora já sei tudo.